Good day. It's time for Dodger baseball. Oh, sorry, wrong program. I apologize there. Welcome to another edition of the Constitution and American Life with the Friends of Publius. Just in case you forgot who we are, I'm David Richmond. I was a teacher for 35 years and also the director of the We the People and Project Citizens program in California for the Center for Civic Ed in those 36, 37 years. We also have with us Professor Tim Moore, former high school teacher, also did We the People as a high school teacher coach, and now he's with the Center for the Study of the Constitution at the University of Wisconsin. And I just found out recently that his favorite song is an R&B rendition of Up, Up and Away in My Beautiful Balloon there. So I want you to try to find that on Spotify or something. We also have with us Professor Chris Kavanaugh, one of the most acknowledged best civic educators in the United States of America. He was born and raised a Hoosier, but now he lives in Bismarck, North Dakota, but Indiana will never leave his bloodstream there. And I just found out recently that his favorite movie is The Sound of Music because the hills are alive in North Dakota there. And we also have Dr. James Michael Williams, the University of San Diego professor in political science, comparative politics, and also some director of some, I don't know, fuzzy social liberal program there at the university. And I found out recently that his idea of a great first date is to go to the state fair and get deep fried Twinkies and frozen bananas as a treat there. So ladies, that's the guy you want to go with it. Now, we are privileged tonight to have with us a special guest, the person most responsible, most responsible for the knowledge and skills that Professor Williams possesses today. However, I did read a document that his final evaluation of Dr. Williams as an undergrad, that he was somewhat disappointed in his academic potential due to the fact that he was a San Francisco Giants fan there. So with us tonight is Professor Dr. Retired, by the way, the other retired member of this panel tonight, Del Dickson from the University of San Diego. Professor Dickson, similar to Professor Williams, possesses both a doctorate and a JD. He earned his PhD from the University of Southern California, or for us Bruin fans, the University of Spoiled Children. But this is, you confused me, Del, because you also have your JD from UCLA, which must make the athletic program and you schizophrenic, or to some degree.
That's exactly right, but both halves of my brain come together to hate Notre Dame.
Oh, don't go. You've lit up Chris now. Although I don't think Chris is much of a Notre Dame fan there. Professor Dickson has taught multiple courses in his 34 years at USD, including constitutional law, comparative law. He was also the pre-law advisor, and he is the author of 2 books. Tonight, we're going to be discussing the right to jury trial and issues related to this principle. Let me start out by saying that I understand, finally, after I don't know how many episodes we've done, that we don't have a perfect system of government, and we cannot allow the perfect to be the enemy of the good. And this applies across the board to all principles, concepts, clauses, articles of the Constitution. However, there has to be a however, in my continuing decline into unhealthy cynicism and loss of my principled idealism, I have come to believe that our criminal justice system is broken to such a degree that I don't know if it can be repaired. And I suggest to anybody watching and to my fellow colleagues that you might want to listen to the podcast. There's a program called Serial produced by Sarah Koenig, and she's won massive awards. And she spent an entire year, all right, at the court system in Cleveland, Ohio, and has this really long series on the criminal justice system. And by listening to that, I've really gotten down on our criminal justice system. But again, that's to be debated tonight. But like most other principles and concepts embedded in our system of government, we find the trial by jury both in Article 3 and in the Bill of Rights. I believe it looks good on paper, but in the everyday lives of many Americans, it does not live up to its promise. What's my evidence about this? 96% of all criminal cases are plea bargain, which leads me to believe that I don't even know if trial by jury is that important, since such a minuscule number of cases actually end up in court in this system there. And lastly, one of the most common jokes about juries that you will hear is when you go into court, you are putting your fate into the hands of people who weren't smart enough to get out of jury duty, which says something about, all right, the whole process of trial by jury. So today we are going to be discussing the requirements of unanimous decisions in criminal cases, jury trials and due process, and how these are connected to our founding documents. So gentlemen, let's start out as we normally do. I do want to acknowledge that this question opens up in somewhat a different way, not with a quote from a founder or a famous political scientist or historian, but from a play and movie, 12 Angry Men there, and leads me to believe, you know, what time of night and what were you drinking when you wrote this question. But gentlemen, any general recommendations to students and teachers about the question? And we've kind of tried to guide them into what we might call booby traps or landmines. And so I love it to start with Professor Williams. Any thoughts on your mind as far as what you might advise teachers and students about this question?
You know, when I first read it, I thought that it was a little more straightforward, a little more focused than some of the other questions in there. But as I was, doing the research for the week and thinking about it, I don't know if it's a booby trap. I would encourage students, though, to think about jury duty in the larger field of sort of just civic participation, political participation, and the pros and cons of any kind of political or civic engagement. And I think if they can zoom out a little bit from the narrowness of the question and think about jury duty in that sense, and to think about people's reaction to it, and to your point, David, the jokes that we have about jury duty, I think that may be a broader reflection on maybe how we might feel about participation more generally. So that'd be my suggestion.
Thank you. Professor Kavanaugh?
I just rewatched, I shared with you guys in a text message that I just rewatched this movie for the first time in a long time.
The original, right?
The original, yeah. Henry Fonda produced it. Not only was he the star, and he was a producer of it, which I didn't realize. And I hopefully some of the students will maybe watch it. It's worth a watch. It really is. But one of the things that lends me to understand how it plays out in the movie, right, or in the play, which becomes a movie, are the biases that people bring into the jury room. People do not check at least in the play, people do not check their bias at the jury room door, and you can see that play out. And the fact that it's all white men. There are 12 angry men. There are 12 angry white men in the film. So I think that students make sure they point that out and talk about the process, because the person on trial was Hispanic or implied to be Hispanic. And there were no Hispanic folks on the jury, which I think is very telling given the fact that they came out in the 1950s. So, in terms of the lead-in quote for students, I would make sure maybe take the time as a unit to watch the video.
Professor Moore.
Yeah, I too watched it. I think or late last week, and it struck me as the same thing. It's how different jury, at least the makeup of juries are. now compared to when the movie came out in the 50s. Predictably, I would say, again, we're into a legal unit here. And I think in terms of scoring well, don't confine yourself to all the case law. Know some case law, because that there will be people on the panel that will want to hear that kind of stuff. But you might run across a person that wants to know a little history too. So I would urge students to dig back into the English roots maybe a little bit. Certainly do a little Federalist, anti-Federalist reading on juries, because I think the history, in terms of your presentations and you demonstrate a fuller understanding, and that's one of the prongs of the rubric, if you're invoking history as well as case law. So that would be what I would say. Don't ignore the history.
Professor Dickson, I'm assuming you've seen the question. If you were gonna, have to, let's assume like this was an assessment question that you gave to your college students, what would you, hope that they were going to talk about?
One of the things that I hope that they would talk about is to remember how important the jury is to any democracy. The jury is the hill that I'll fight and die on when it comes to constitutional rights. I would give up almost anything else before I gave up the right to jury trial. And the reason is it's one of the it maybe is the only truly democratic element that is built into the Constitution. The Constitution was basically designed to restrict the powers of the federal government. The jury is the one element that actually empowers ordinary people to be part of that government and to check the government themselves. And I think that students ought to remember that that's what the jury is there for. The jokes are all well and good, but most of the jokes that I hear have kind of, I don't even know that they're implied anti-democratic values built into them. There's kind of an elitism, kind of a snobbery built into it. And they ought to listen to those jokes, and they ought to laugh at those jokes the first 500 times they hear them. But they ought to remember that there's an edge to it too, that there is kind of an implication that ordinary people are too dumb to figure these things out for themselves. And so come into it with an open mind is I guess all I would think about and recommend that students do.
So I guess the three of us are going to leave. Del, and you and Dave can actually have a conversation for the next hour, and I'll just sit and listen.
Professor Dickson, Tim really enjoyed the response because it was a good, back slap on the side of my head there, which I appreciated the way you handled that, and I'm sure we'll get into it a little bit. So, Professor Moore, we are going to start with you. I know this is presentism as far as you see this question as a legal question. I envision a panel of all attorneys here, but I fundamentally agree with you that kids need to be grounded in the history and philosophy, of Article 3, Section 3, and the Bill of Rights. Number 5 and number 6 there. So let's start out with, I think one of the favorite Federalist Papers of a lot of people and of this group is Federalist Paper number 51. And it juxtaposes this notion, and it's really talking about separation of powers, checks and balances when it talks about, the reliance on the people is great. However, you need auxiliary precautions. Do you see that as framing and providing the foundation in so many ways of the balance between individual rights and common good implied in trial by jury and due process?
Sure. I'll go with that. I think well, first I like the quote from Federalist 51. That sentence is interesting. I'm thinking of Dell's comments about the jury box may be the only overtly democratic commitment in the Constitution. It's so I have to kind of chuckle a little bit because Madison's sentence when he talks about auxiliary precautions, I mean, it's juxtaposed to democracy. In other words, we need auxiliary precautions against democracy. So I hear an irony, Dell's commitment to the jury box being democratic. So in Madison's terms, it might not be one of the auxiliary precautions he would have preferred if he was so down on direct democracy, which he was. But to your point about there are some founding principles, the way I see it. There's a communitarian principle, a classical Republican commitment to the community being involved in the administration of justice. And if you insert individual rights into the equation, I think there's an individual liberty equation that a jury has to sort out. So balancing community interest with individual liberty, I think, is a nice set of founding principles I think you can see within the jury provision.
Yeah, and and partly the direction I was going is this is obviously a check, all right, and where Professor Dickson was talking about this is a check on the power of government by having citizen juries, but juries don't work in a vacuum. They work with a judge who is a government official, and I've kind of come to the conclusion the judges dominate, so much of the criminal justice system. So in that sense, that's a separation of powers almost, or division of powers, I guess would probably be more accurate, Tim. Don't you think?
Well, we might get into this later about this idea how much leeway a jury has as opposed to a judge, judge's instructions and all of that. I hope we can get into that later. But and I think some of it may have to do with whether you want to see the formal institutions of government as the operating systems here. I think juries, in some ways, is a fourth check, a fourth branch of checking that should be on par with the other branches, frankly. And that's why I think some people are more comfortable with juries, trumping judges and ignoring judges' instructions.
Gentlemen, any thoughts about that question or what Professor Moore has said here? Anyone want to jump in and respond?
Well, I don't disagree. I keep thinking of Jack Rakoff, and he is in his book Original Meanings. Yeah, he had said that the two most important rights that the colonists got from their British brethren was the concept of no taxation without representation, and the right to a jury trial. He said that those two are the most important. I think and you see that reflected because in the body of the Constitution, in Article 3, they protect the right to a jury trial. It's one of the few individual rights embedded in the body of the Constitution. So I think that speaks to it. And I keep thinking of I wanted to find this quote, so I looked it up. So forgive me, but it's from Tocqueville. And it's a great quote from Alexis de Tocqueville. And he said, by obliging men to turn their attention to other affairs than their own, it rubs off that private selfishness, which is the rust of society, which I think that speaks exactly to what Tim was saying about this communitarian idea of a jury trial.
Professor Dickson, I want to kind of go back to, and I should maybe, and this is to you and Professor Moore. Is there an antecedent to jury trials? That is, did England have jury trials, or is this an American creation?
It's not an American creation. It happened in Britain, and I don't want to steal Tim's history, so Tim can give me a high sign here. But the reason why Britain had juries before America had juries, it was a freak of history. During medieval times, Britain was deciding guilt and innocence by trial by pain. It was trial by hot water, trial by ordeal. And in 1215, the Pope said, knock that stuff off. You can't torture people to figure out who's guilty or who isn't anymore. But Britain hadn't developed professional judges yet. Juries were literally the only alternative they had to decide cases. And so Britain fell back on it. And that's how the jury developed originally. And then we adopted that for our own reasons. And I think we'll probably get into that later. I wanted to add real quickly, Madison, certainly far more than the other two authors of the Federalist, Madison was not averse to juries. And in fact, I think, Tim, you said it just exactly right. Madison was suspicious of democracy. He did hate the Athenian jury. The Athenian jury is kind of the template, but the Athenian jury was majoritarian, and the American jury is not. And that is the difference, and that's why Madison he was not a critic of the jury system, because you had that additional guard in there of requiring unanimous juries in a criminal case.
All right, for those of us who are, of course, the slow learners, Del, could you clarify what you mean? They were not majoritarian?
In Athens, juries in Athens were anywhere from 200 to 5,000 people. And they would go in, listen to a case. They wouldn't deliberate. They would just vote at the end of the case. And majority ruled. And that was the principle that Madison objected to. Because as you know, as he said, in the Assembly of Athens, if everybody was Socrates, it would still be a mob. And so the jury, by requiring unanimity, means the majority can't just steamroll the minority. You had to take everybody's views seriously. And that reassured Madison. Although it did not reassure Hamilton. Hamilton in number 96, he just basically says, I don't even know why the jury exists, but we can't abolish it right now, so we'll have to put up with it.
So, Del, you brought, again, and I asked you, and we talked a little bit about the English. To my knowledge, and again, I'm the slow learner on the panel, Blackstone is a key figure in the understanding of jurisprudence and criminal justice and the system. And I'm wondering, and I don't know if he's the originator of this or if it was Benjamin Franklin, but I used to use this quote 35 years with students to start off my discussion of due process and criminal justice. And it is, and I don't know if it's the accurate quote, but it is better that 10 guilty men go free than one innocent man be falsely imprisoned. And I'm wondering, is that kind of the foundation of the reason why we require unanimity on criminal cases?
Yeah, I think that is exactly right. And my memory is, I think maybe it was Al Capone who said that. It actually was Blackstone who said it first, but they both said it. Both Blackstone and Franklin said it. Blackstone, to go off on a 5-second tangent, Blackstone was much more influential and much more famous in America than he ever was in Britain. They basically ignore him. We took him very seriously. Ben Franklin, the other founders, the other framers took him very seriously. Blackstone was a fan of juries, and that was the underlying principle for him, that it did give ordinary people a voice, and it also meant that the state would not necessarily get its way. When somebody is prosecuted in any country, the state kind of by definition is saying, we want this person convicted. And a judge as an agent of the state has their own bias in that regard. And I should point out, David, that in authoritarian governments, they often make that statement in exactly the opposite way. We would rather have 10 innocent people put in jail than allow one guilty person to go free. And the jury is one of the ways that we use to do that. Real quickly, unanimity goes to reasonable doubt, and it also goes to representation. Reasonable doubt, again, the state has all the advantages. The state wants you convicted, you're halfway there already. The one advantage that they don't have is the burden of proof in this country. And the burden of proof in criminal cases is reasonable doubt. And for me, if you can't convince 12 ordinary people of your guilt, that by definition is not beyond reasonable doubt, that the state has failed to meet its burden. And the jury is the guarantee of that. The second element there is representation. I mentioned this briefly before. A unanimous jury means that nobody can be ignored. Nobody can just be steamrolled and just pushed off to the side. You have to take everybody's view on a jury of 12 seriously. And that if 12 Angry Men was all white men, juries then were more diverse than that. Juries now are much more diverse than that. But again, diversity broadly defined, not just race, economic class, education, partisanship. You can't just go in and just say, well, you're the one Democrat in this panel. We've got 11 Republicans, 1 Democrat. We don't care what you have to say. Unanimity requires everybody to be taken seriously. There's a downside to it too. We'll probably get to that. I've said enough.
Just thoughts?
Real quick, that you mentioned Blackstone in his writings in 1765 were so important that 9 years later, with the Intolerable Acts, especially one of them, the Administration of Justice Act, the colonists, which basically created the admiralty courts and obliterated local trials. The colonials quoted Blackstone over and over and over in 74, 75 as a result of that one of the 4 Intolerable Acts. So they really riff on Blackstone heavily.
I would add for 5 more seconds on that. In the United States, in the American colonies, the Crown, the government, the British government got sick of juries letting people off that they wanted convicted, and they started dragging colonists up to Canada to try them up there to get around the requirement for juries. And this is one of the reasons why the founders and the framers really valued the jury system.
And the word vicinity, tried in the vicinity, right? Or the old English word vicinage, right? So you got to be tried in the vicinity where the crime was committed. So yeah, no getting on a boat going up to Nova Scotia, or no getting on a boat going over to England. And for students to think about this in a contemporary sense, think about Hong Kong, right? Think about the people of Hong Kong that were going to be tried, or they're going to be accused by the Chinese Communist government, and they're no longer going to stand trial in Hong Kong. They're going to have to be taken back to the mainland. And this is the same principle in that regard, because how are you going to get your defense witnesses to the mainland? How are you going to get your attorneys to the mainland? So that principle that Tim and Professor Dickson just described is being played out in Hong Kong, and one of the reasons for the umbrella protests.
And the anti-federalists made that argument too, that with the federal courts and the jurisdiction of federal courts, people would get drug away from local trials to a far distant court. So that vicinage thing it has always been in the American DNA, that commitment to local trials.
Well, I'm wondering, Professor Dickson, I've read a little bit in the last 6 months. There are some people out there advocating reform and getting rid of unanimity. What's your thought about that? And I'm just curious of I've read why they say what they say, but what are your thoughts about that? Well,
yeah, the best argument, I think, in favor of less than unanimous juries is the unreasonable juror principle. That in any group, chances are there's going to be somebody in there. Let me put it to you this way. There's a story, and I'll make it very quick. Every group has a dynamic. And if you look around in any group that you're in and you can't spot the asshole, chances are you're the asshole. and this is true of juries too. There's going to be one unreasonable person in a group of 12. And this gives you a way around them. But really the only thing that unanimous juries cost is efficiency. Because it means that you're going to have more hung juries, which means you're going to have more retrials. To me, that's a small price to pay. Plus, it's a really slippery slope. Once you say 11-1 is okay, well, what about 10-2? And then pretty soon it's just a majority verdict. And there are problems with that too. And if you happen to belong to a minority where maybe statistically you're going to land one juror on any random jury, you're not going to be in favor of that.
So Chris, partly what we want to do tonight is talk about some of the controversies and I think problems with jury trials. And I'm wondering, since you are our legal scholar of this group, yeah, you are. Again, that might say something about the group, not about you, but you are.
It's a low bar.
So does the First Amendment, and this, especially in the last 20 years, this has become much more of an issue. Does the First Amendment in any way conflict with the Sixth Amendment trial by jury and due process?
Yeah, I'm going to pose a question for the students that may watch this. So let's suppose that you're on trial, a capital case. You're on trial. It's a murder trial. And so you're on trial for your life, literally. And the family of the deceased is sitting in the front row of the jury room, and they're all wearing big buttons of the deceased, the young man who you're accused of killing. And so your lawyer is going to argue that that's unfair because, you got the mourning mother in the front row. She's crying, she's in tears, and they're all wearing buttons of this young man who was murdered. You're on trial for your life. Does their First Amendment right to free expression outweigh your right to a fair trial? So I'm not going to answer that because I want the students to look that up, because it's an actual case. I'm not going to give you the name of the case. I'm sorry, I'm going to be that way. But Professor Dickson just said if there are 5 people in the room and you look around and you're wondering who the butthole is, it's going to be me. By the way, thanks, Professor Dickson, for taking that off of me, because as I've been accused of using language that may get us a bad rating. So I think therein lies a great dilemma.
Well, let me ask you it this way. All right, we know that the leading case here is Shepard versus Maxwell. All right, back in the 1960s, it became a TV program. The Fugitive was, kind of based upon that.
Sure.
Has it become more complex because of social media and First Amendment rights and jury trials? In your opinion, Chris?
It has, but I don't know if there is any. I'm not aware of any case law in terms of, posting on Twitter or posting on Facebook or posting on Instagram or whatever your platform of choice may be. Now, can I go back though? Because there are a couple of cases that moved away from unanimity, right? I think Johnson versus Louisiana, and I can never say this right.
Apodaca?
Yeah, Apodaca, is that how you say it? Apodaca v. Oregon, both in
like my impossible eclectic. Yeah, Apodaca.
That is going to tickle me. That's funny. Both cases are in 1972, and I think you see the Supreme Court moving away from requiring that unanimity, and it's kind of like been chipped away ever since in terms of is it a capital case? Is it a hard labor? Is it, what are the circumstances of the case? So there's some case law out there for the students to take a look at the Supreme Court moving away from that unanimity. But back to your original question, David, I'm not aware of social media in terms of the confrontation with the Sixth Amendment.
Well, and I want to get to, I think Dell wants to chime in, but a very close person to me recently served on a jury. And of course, the jury is told not to read anything about the case, but, their first day of deliberation, this friend of mine went in, of course, to the jury room to start deliberation, and half of them had looked up, certain things on social media. And, to me, that compromises the whole foundation of the jury trial and fair trial. So that's my reference here as far as how social media might compromise it. But to the general question, does anybody else have thoughts, comments on that, Del?
I do, very quickly. Apodaca involved Oregon, Johnson involved Louisiana. As it turns out, those were the only two states to really go in for majority verdicts in criminal cases. The federal government never did. The other states never did. And it caused eventually the Supreme Court to rethink the question in 2020. And they kind of went back on Apodaca and Johnson in Ramos v. Louisiana. So the times are changing back, as the movie says, and unanimous juries are kind of once again the standard.
Thank you. Thanks.
Anybody else thoughts about First Amendment, Sixth Amendment? I'm just curious, and social media these days and fair trials.
Again, may I very quickly?
Yeah, of course. No.
There are in Canada and Britain, for example, they came down squarely on the side of fair trial. It's impossible to report details of trials there. The media is squelched. And the United States took exactly the opposite preference. We give privilege to the First Amendment, free press, free speech. So they're both reasonable positions, and maybe you can compromise somehow. But when you have to pick a side, America went one way, Britain went the other. And it's a good point of debate, I think, which is more important when they inevitably conflict.
And I think we've talked on here about how rights are not absolute, right? And I think this is an interesting question for students to think about. I mean, we all know that there are time, place, and manner restrictions on First Amendment. I think we could all argue maybe a courtroom is a place where there's more limited First Amendment rights. But it raises the question of, is a right to a fair trial somewhat more absolute? Or is it, when we start thinking about the sort of the different rights that we have, would a fair trial be one that we would not allow as many exceptions to? I think Dell's comment about the way Canada has dealt with it versus the United States is super interesting, because it does seem to curtail the fair trial.
Does the word public mean anything? I mean, in the amendment, speedy public, does the press say they're the mechanism of the public phrase there in the Sixth Amendment, or is that not? I mean, it seems to be pretty heady if you're an amendment, a press, that we are the vehicle of public.
Del?
Yeah, you're
that's
exactly right.
That
That is exactly what the press says. We represent the public in these trials. The Supreme Court has been fairly
Are you
consistent.
buying that? Are you buying that?
The Supreme Court, I agree with, has said no. The press is not the people. They may be representatives, but they are not the sole representatives of the people. So the press really, maybe they have a slightly privileged position, but public trial means ordinary people get in, not just reporters. And I would add very, very quickly as well that American judges have ways to deal with conflicts between the Sixth Amendment and the First as well. They can issue gag orders. They just have to meet a very high bar before they do that.
So it was nice to hear from you, Professor Williams. I've been sitting there wondering if, being here with, both your major and minor influences in your academic life was overly intimidating, kind of like, I don't know, the Giants facing the Dodger pitching kind of situation. It's just overly intimidating here. So I'm going to give you a chance to speak here. And that is, and I think it's important. I really do. And actually, Mike, you've been the biggest influence on me of understanding international perspectives. And I know the courts wrestled with that over the years, is how much should the American judiciary, reference or even think about international notions of justice here. But so I'm wondering, to what extent, if any, does the U.S. jury system differ from other liberal democracies?
Yeah, and this is where you can kind of, it's going to be a little predictable for the students, given what Dell said about sort of the birthplace of democracies, modern day. You see, you see some former British colonies, Australia, Canada, for example, definitely Wales, Ireland, Scotland. Those are all places where we see juries like we kind of have in the United States. An interesting example there I found, I'm going to defer to Dell on this because I know he's done research in Switzerland. Switzerland was another case that at least I found had jury trials that seems to fit with what you've taught me, Dell, about direct democracy in Switzerland, but that wasn't one that I would have had on my list. But what I found interesting is that, so no, it's rare. Like the United States is kind of a unique. There are some countries that don't have jury trials that just kind of stand out to me that I wanted to share with students. India got rid of their jury trials in the 1970s. It's considered, probably the largest democracy in the world. South Africa got rid of jury trials after apartheid. Juries were used really to bad effect during apartheid. So South Africa does not have jury trials. South Africa is considered probably the most democratic country in sub-Saharan Africa. And then Israel doesn't have jury trials, and Israel kind of stands out as being one of the countries in the Middle East that we might call democracy. So just in terms of like looking around the world and seeing some major countries that don't have it, I think is interesting. And then finally, I'll just add, there's a system that other countries kind of have. It's kind of like a middle system where it's not jury trials, but sometimes it's called lay assessors or citizen assessors, where 3 or 4 folks will work with judges. This is not in adversarial systems, it's more in inquisitorial systems. But these people will then sit with the judge, and it's not like a unanimous, but they'll just work with the judge on findings of fact. And that's something that I haven't researched or know much about, but I just wanted to raise that with the students. But Dell, yeah, I'm not intimidated, David, but I am enjoying listening. This is good. I like this. And Dell taught a pretty good comparative law class. So he's not just all US jury system. He knows the other things as well. So I'm going to defer to him on this as well.
Well, he just deferred to you. Anything we can learn from the international arena, especially liberal democracies, about jury trials that you'd like to point out?
There is, but I think most of it is terrible warning rather than an example. This is one of the cases where India, for example, for a long time, their transition to getting rid of juries, they had advisory juries. And that was basically useless because the judge was free to ignore the jury verdict and just substitute their own opinion. And so the jury really had no power at all. The one thing that Mike mentioned that I think is interesting and we'll mention very briefly again is the lay assessors. Lay assessors became popular, especially in the communist bloc after 1917, where again, it was kind of a bow toward democracy, the great Soviet system. 2 ordinary assessors would sit with a trained party judge. And the result was completely predictable. The professional judge, the Bolshevik judge, always just ran the show. There is an alternative, though, in the British system. British have what they call lay magistrates, where a panel of 3 lay judges sit with a clerk. So it's not a judge, it's just the legal advisor, and the legal advisor has no power. But that really gives a 3 kind of semi-trained jurors the power rather than 12, as we do it, untrained jurors. That's a different issue, how badly we train jurors, because essentially we don't.
So, Dell, you get the $66,000 question today, and one that I think we have plenty of time to delve into, and that is, I think, some of the core issues that confront, which I talked about, somewhat briefly in my opening. I have a general view that and I know this is contrary to yours, I know that now, I think we overly romanticize jury trials. And so I've got a list of issues that I'm hoping all 5 of us can maybe get into the discussion here. And I am wondering, before I get into them, Have you ever served on a jury, Del?
I have. In fact, I've sat on 3. And
How did you get through voir dire? I mean,
I was shocked.
Yeah.
And it happened 3 times. So
Okay, so maybe this is contextual about community and where you live. As I said, a very close friend of mine just served on a jury, and they were outraged by the whole experience in the jury room, from the selection of the foreman to the deliberation, the role of the bailiff, the whole process. And they asked me what they can do about it, and and I said, well, write a letter to the judge, and the whole thing. So so I'm a little questionable. And then you said that juries, today in America are more diverse. I'm here in Bakersfield, California, Del, and I will tell you, we have one very famous jury trial of a young Black youth, in which there were no Black jurors. And then this friend of mine just served on a jury in which the defendant was Black, and there were no Black jurors. There were 2 Hispanic jurors there, and stuff. So I'm wondering about this notion of peers, and I'm asking you, Del, but can we deal with the notion of what they meant by jury of peers? And Tim, I'd also like you to chime in from an 18th century view of that. All right, because we know the 20th century is way outside your realm of understanding. But what do they mean? What does peers mean? Does it just mean from your community? But if I'm a 20-year-old Black youth, doesn't peers mean that I should at least have somebody near my age or somebody in my racial group? Chris.
I have a question.
Yeah.
Where in the Constitution does it say peers?
Well, it doesn't, but it is part of the language that we now talk. Don't get snarky with me, Professor Kavanaugh. It's part of the language of civic education.
I'm just being a textualist.
Okay, thank
my
you.
inner Thomas.
Of course you are.
All right, thank you, Judge Thomas.
Well, peers,
and again, in all seriousness, Chris, are you telling me it's not part of the civic language?
Well, it's part of the civic language. It's not part of necessarily a legal language.
So are you saying, again, that might answer my question, there is no requirement whatsoever?
Well, no, we know there's a lot of case law that will come out in terms of like putting people, like-minded people in the jury that are similar to perhaps the defendant, or women, right, on juries. So we know there's a whole litany of case law that will establish that.
Okay.
That was a snarky way for the students to understand that the word peer is not in the Constitution. So sorry, I apologize.
No, don't apologize, because I like your snark. But so tell me, Professor Kavanaugh, what does peers mean to you? Although it's not part of the Constitution, but when we talk about trial by jury and it's going to be from your community, does a defendant deserve a jury that reflects the entire community?
I don't know that it reflects the entire community, because that might be an impossible thing to do. But I would go back to the idea that concept of language, and I think we spoke about on this program before, that I found, and Tim, you guys can maybe back me up on this, is that when people will go on trial in a community, say Boston, right? There was the idea that if you're serving on the jury today, we think that, you have no prior knowledge of the defendant, you have no prior knowledge of the witnesses. You go through that whole, when you go through the voir dire, or seating the jury, you ask all these questions. If you go to colonial times, that was important. The idea that you would know perhaps the accused, that you would know some of the witnesses, and so you could attest to their truthfulness, and so there was an idea that you would know these people, and so that therein you are a peer within the community. Does that make sense?
Yeah.
Yeah, I think in large part this idea of peers has a lot to do Well, it's actually, I mean, the Magna Carta says that, but there's a class statement to that. Rich people didn't want to have anybody in a jury box that was a poor person. So originally, peers, there was an economics designation to that. But I think for the American context, it often strikes me as peers equals the vicinage statement. There was this assumption that the people that are geographically around me, the vicinage, that's my peers. So I think it kind of maybe evolved more to a geographic designation than a economic status designation.
But at some point, it became racial. Would you agree to that?
Oh, well, sure. I mean, because jury, talk about jury nullification in the South. If that's another movie, that's To Kill a Mockingbird. There's jury nullification there too. So yeah, I think, but the whole question of diversity in the communitarian impulse in the jury, I find really problematic, because I don't know that our commitment to, and I'll be pejorative here. I think radical diversity commitments really make it difficult for any notion of a communitarian impulse in a jury box, because society is so fragmented into our various tribes. I don't know if there's any peer principle in radical diversity, our commitment culturally to that. I think it presents real legal problems in defining that jury of peers.
Yeah.
Tim is absolutely right. I mean, you have to go back to 1215, to the Magna Carta, to see where the word peer becomes attached to juries. And there it was class, and it was more specific even, that if you were a baron, you were not going to be judged by anybody ranked lower than a baron. Peers was taken literally there and very narrowly. We've taken that same word and expanded it to mean basically citizen and maybe member of my community if you go with the vicinage. One exception to that is military juries, interestingly enough, that still defines peer narrowly. You will not be tried in the military by anybody of a lower rank than yourself. So there's still that narrowness in there. But do I have a right to be judged by somebody who has every element of my background that I do? No. But I do have a right to be judged by a fair cross-section of the community. And to the extent that doesn't happen, that's a problem with the system. That's not a problem with the jury as a jury.
Yeah.
So you would agree with me that there's a problem there?
In individual trials, absolutely.
You don't think there's a systemic problem?
It might even be systemic, but it's not inherent in the jury. It's inherent where people aren't encouraged to serve on juries. It becomes easy to get out of juries. It becomes too expensive to become a juror because you can't miss work and your employer, for whatever reason, has told you you can't. There are problems with the system for sure, but they're not inherent to the jury system.
Mike, you were going to say?
Well, yeah, I was going to bring up the more system-wide argument. And also, I think students need to make sure they distinguish, like, as a defendant, well, there's a difference between a lawyer can't disallow someone because of race, right? That's more of a negative right versus a defendant has a positive right to have 30% of the same racial composition on the jury as there is in the community. That's just a different way to think about it. I think if and I do think it has to do with the system about how lawyers pick juries. I mean, if we really wanted something that was going to be more of a cross-section, we'd have a lottery system, right? You would have a lottery system where the names in the bucket would be, if 50% of the community is Hispanic, 50% of those eligible jurors would be Hispanic, and then you would just randomly pull out 12 folks, right, and just force them, like that. The attorneys don't choose; they'd sit on the jury. You might get a better cross-section there, but that's going to run into other issues, obviously.
Well,
one quick addition to that, this difficulty of, or the evolution of the word meaning of peer. Even at founding, you in many states, you had to own property to be on a in a jury. This idea of there's a class economic component to the jury, so that continues on in a small degree in the American legal colonial system, in the early American system.
Dale, I'm sorry, but I'm going to push back, and actually I'm going to push back on you. You guys seem to be poo-pooing. All right. And you say, well, yeah, there might be a societal problem, but it's not a problem with the jury system. Well, the jury system is not disconnected in any way, shape, or form from the larger culture. And we know that to be a fact of history, as we talked about race and juries. And this is my specific issue. I do believe it's also class. And referencing again, this friend of mine had just served, and it was a murder trial, and it went on for 3 weeks, is nobody on the jury had any concept of how the life of the defendant and how they lived. They had no concept of the community, the section of the community where they lived, all right, the life in which they lived there. And to me, that's similar. They were all middle-class people, which is the preponderance of people who serve on juries. And again, I'm going to talk about my community. That's the preponderance. They're middle-class people, they're working class middle class, or they're professional middle or upper middle. And their first response is, well, I would never do that, or how could they make that kind? Because they have no idea what it's like to live on the poor side of town. And like I said, you want to separate that. The jury system is great. The culture might be a problem. And I struggle with that. And Mike, you and Del both seem to be kind of saying that. So tell me where I'm wrong.
Let me put it back the other way. I'm going to go ahead and say you're absolutely right. Let's get rid of the jury system. How is that judge going to fit your bill any better?
Sorry.
With 12 ordinary jurors, you have a cross section, and if it's not a perfect cross section, it sure as hell is going to be more representative than that one judge. And again, I think those are fixable problems. If the jury isn't representative, it may be that your community isn't representative, and that may be unfixable. But if certain elements of that community have been excluded from jury duty, or the rules of voir dire have made it easy for lawyers to eliminate them during the selection, that's a problem, but that's a fixable problem. That one judge is going to be that one judge forever, and that is not going to be fixed.
Yeah, I would add to that. No, I forgot what I was going to say. I'm not going to add that anymore.
Well, I'll jump on real quickly. American Bar Association survey of 2020. I was just kind of trying to do a little reading, and one of the things the judges, prosecutors, and defense attorneys all rank jury trials as fairer than bench trials. So the idea, back to Dell's proposition of getting rid of jury trials, even people are going to say, no, there are flaws in the system, but if we went to simply bench trials, that's not going to be nearly as fair.
Well, that was something we're going to get to, but you brought it up, Chris. So is there any circumstance, I just, be the teacher you are and you're teaching kids, if you were a defendant, when would you choose a bench trial? Under what conditions?
Well, if I was accused of committing a really heinous act, perhaps involving a child, and I could not get a change of venue, I might think about going with a bench trial simply because the bloodlust of a community may be up, right? In terms of, do I feel like there's no way in heck I'm going to get a fair trial in the vicinity or in the community where the crime was committed because the act was so heinous. That kind of idea. If I could not get a change of venue, I might go with a bench trial. But it so much of it depends, though. It depends on my financial wherewithal. Can I afford an attorney for a long, drawn-out trial? If I can't, then I don't know. Those are other things to consider, I believe.
We have one of those right now in Waukesha, the guy who went through our holiday parade. It's come out that he's weighing all those issues. Just to Chris's point, would he prefer a bench trial rather than a jury trial? And he's actually right now wanting a change of venue. So,
well, I think that's a great case example in terms of, I'm not saying the folks at Waukesha, rightfully they have a reason to be outraged by what happened, but
right.
Does he think he can get a fair trial within the community with the jury members from the larger part of Waukesha?
Mike, you were going to say something?
Well, I think this is where it's telling, the statistics on how often there are plea bargains versus the jury trials. And I just, this is more from my experience of, my father practicing criminal defense and hearing all of his stories. To your point, Dave, in a criminal trial, the lived experience of the defendant, you really, as a defense attorney, you want to get that story in. But that's not really what the trial as a system is about. It's about the act and about the intention, and it's about trying to figure out. I'm just saying, what you're looking for is something maybe a little different than the criminal trial just as a system. But then my experience has been, DAs, they don't want to lose a jury trial. So they're going to go to a jury trial when they really think that they have the evidence to prove it and that they don't think the defense has a story they can tell. And I think the defense attorney is going to roll the dice when they do think, either because of the rules of evidence, because of the type of client they have, that they can tell a story that they can then, persuade 12 people about their story, or at least persuade one of them, not 12, persuade one of them their story. And that's just how the system is built up. I think, again, I find this issue so interesting because, we've talked about it a few times, and you take a different stance on this issue than you do with others. And I'm always on the other side. I'm like, how is this happening? I'm just seeing the jury as part of a larger system. I'm not disagreeing with your critique of the jury system, but to Dell's point, I don't think getting rid of the jury system is going to get rid of those problems.
Oh, I'm not asking to get rid of the jury system. I think we can make it better. And one of the problems is the system is somewhat overwhelmed. Most communities, the public defender's office, which defends probably more, defendants than private practice does.
Way more.
I just didn't want to overstate it there. And they're not funded, to the same degree. But the system is somewhat overwhelmed, Mike. And again, the 96%, and very well that a certain element of that 96% of plea bargains, they didn't commit the crime. But because they come from, an uneducated, or poorly educated background, lower socioeconomic, and inbred into that system is a distrust of the system. All right, especially amongst people of color. All right, so they decide, okay, I'll take this plea bargain because I don't want to roll the dice. And to me, that's not a system of justice. And the reason that we find ourselves on the other side is that you're going through an identity crisis. That's what it's all about. There is that, you're in middle age now. You're kind of, I've been the same guy for 40 years, kind of thing. So I just wondered about class, because I think because like I said, my close friend who served on a jury, the first thing when they got into the room, and they were all from working class, and they could not relate to this defendant at all, could not understand. And again, there were no people of his racial background on the jury. And they got down to the way that he spoke, the way that he articulated the English language was brought up in the jury room, and that's justice. I'm sorry. I promise not to rant today, but I'm going down that path a little bit. Yes, Dell.
If I could add two things. The three juries that I sat on, I came away completely impressed. by how seriously people took it. They were all 3 criminal trials. I came away even more of a fan of jury trials than before. But if I were to reform one thing, and maybe, David, this would help, I'm making this up. 99% of the jurisdictions in this country, they don't pay jurors enough to buy themselves lunch. If you paid jurors a daily wage, I have a feeling you would have more working class jurors who could afford to become jurors and maybe take some of that pressure off. Maybe that's one of the places that we can meet in the middle. There are ways to bring more working class, more unemployed into the jury box, and maybe that's the easiest way to try.
That's excellent. Mike? Nothing? All right. My second thing, again, this friend of mine, and it relates to the juries and the qualifications for jury. Is the average citizen capable of understanding, one, the judicial process? And I know judges, and I will say this, I've been in the jury pool numerous times. I've served on one jury, was an alternate in one in my whole lifetime. I think the judges in my community do a really good job of trying to explain the process. But then you get down to the facts of the case. And in complicated cases, it can be a very big challenge to people with average or low levels of education. The jury instructions that this person received, this friend of mine, was 46 pages long. So doesn't that require that we have, I don't know, that in jury selection, that we should have some kind of assessment of their ability to deal with language and stuff? Dell's laughing at me, but I'm just wondering, Dell.
You mean like a literacy test, Dave?
Yeah.
Okay.
Ooh, I got silence.
No, I just think it's very amusing that the person 5 seconds ago was saying we need more working class people in the jury box are all of a sudden saying, no, we need more PhDs in the jury box. We need more professionals in the jury box.
Now, actually, I'm an advocate for professional juries, especially in the realm of civil cases, but we're not talking about civil cases tonight. We're talking about criminal. Like I said, I wish I could, share all the details, but that would take us up, take the whole program over. I just, again, from the discussions with this friend of mine, most of the jurors did not understand the instructions. And it was a murder case. It had 4 different charges. And I think, Dell, you understand this. There's certain contingencies. If you do this, you can't do this, that kind of stuff. And they were so confused through the whole process. So how do you fix that?
There are 2 ways to fix that. Number one, we're all old enough here. Maybe the students listening, maybe things are different now. We all had driver training in high school. Did we have jury training? No, we didn't. And that tells you maybe a little bit about how seriously we take driving versus jury duty. There are a lot of things that we can do to prepare people to be better jurors. And maybe that's something that we can do as well.
I would go back to what you said earlier, Dell, was the fact that, and I would wholeheartedly agree that we can't do that until we actually are going to pay people a little bit more money to allow them to miss work. I mean, I was just in a jury pool a few weeks ago, and I missed work, which is not a big deal, but they gave me a check for $25, right? Which some of that's going to cover parking at a public parking garage where they have us park. And I wasn't there long enough. I missed lunch, but I wasn't there long enough in the voir dire process to be there all day, and I was not called. But then my work finds out, and then they take $25 out of my paycheck, right? And I'm thinking, oh my God, we're quibbling about $25, but that's what that's what people were going to get, and people, I think.
Well, you're still getting paid, Chris. I mean, that's not the issue. It's about the people who aren't getting paid.
Well, that's my point. No, David, that's my point. And my point is what I'm just reinforcing what Dell said earlier in terms of, if we want to take this more seriously, then we need to pay our jurors more money. We need to allow more people to be able to miss work, right? To be able to get some training, to have some understanding of what they're doing before they actually step into the jury box, but we're not willing to do that.
Yeah, and I guess my point to you is, like in our jurisdiction, but in California statewide, and I looked this up, 10 years ago, social studies, history, government teachers very rarely served on juries. Once you said, I teach government and the Bill of Rights, prosecutors would eliminate you immediately because they didn't want to know it all and that kind of thing on a jury. Now, no educator gets excused. And one of the reasons is it's the budget, because as teachers, you still get your daily pay. And in the state of California, and I don't know if this is true in North Dakota, all right, serving on a jury is not deducted, from your absence sick pay. All right, they so you're going to get paid. You're not going to lose anything. So because of that, and they don't have to pay somebody else who doesn't get paid for that day. That was my point. You were still going to get your teacher salary serving on a jury. But there are these other people who, if they serve on a jury, they're not going to get paid from their regular job because of jury duty. But
David, that's what I tried to say. My school deducted the $25 from my paycheck.
Well, in our state, you're supposed to, you check off, you tell them I'm a teacher, they know that, and all they pay for is mileage kind of stuff. And we got, go ahead, Mike.
Yeah, no, I'm seeing a point here where, we started off this discussion thinking about, as a question, how does jury duty relate to the democratic experience, right? And students can make up their own minds about that. But in this discussion, to your point about the costs of participating, and to Dell's point about how ill-equipped we maybe are as citizens to participate, I think those issues are writ large for the political system, right? It's, can the person afford to take a day off work to go vote? What is it? How much money does it cost me to really participate in the democracy in terms of really getting the ear of my member of Congress? I think it's kind of the similar issues, but in this case, David, to your point, this isn't just any ordinary kind of civic engagement. This is where someone's life, someone's liberty is at stake, right? And it should be, according to our founding principles and who we say we are, this should be the area where we are most concerned and where it's most important to get this right and to be equipped and to compensate people for their time. And I agree with you that we're not. I just think it speaks to a more general issue, and it speaks to a more specific issue, David, that you're getting at, of the importance of what jury trials and the criminal justice system mean in our democracy.
Thank you, Henry Fonda.
You like that?
Oh my, yeah, you're Henry Fonda in the jury room.
I'm one angry middle-aged man. And I'm glad to hear that Dave's been in his middle-age crisis for 40 years. Is that what you just said, Dave?
Good shot. Good shot. All right. So we're going to end with something that Professor Moore said last week. It seems to be this theme that we're developing as we go back. But last week, Professor Moore implied that jury nullification might be a way to enforce the rule of law, as our last week's topic was the rule of law. But I got to ask you, Professor Moore, wouldn't jury nullification violate procedural due process, since jurors would be going outside the bounds of jury instructions?
Well, I'm a double down. So here we go. First of all, I don't believe that law should be the sole province of courts. I think there's a danger there. I think it tends towards elitist professionalism. So I mean, we have we have awful instances of jury nullification, but we also have some examples where juries said, they play the BS card, where they get their instructions, or I mean, this whole matter of that the judge or the legal system determines law, and then the province of facts is the jury. Well, that seems to be bifurcated to me. Why wouldn't, now again, well-informed citizens should have a role to weigh in and say, occasionally, we don't believe that your due process that's strictly law, that's strictly legal, is relevant. There might be some extenuating circumstances that we would say no and ignore your instructions and reach a verdict that is not according to law. So now that's because I see rule of law in a much more deliberative process than a strictly legal process. So that's where I was coming from.
I thought rule of law was evolutionary.
That's my point. It evolves in the British system. It evolves through a rattle and hum between institutions. I'd say it's more of a dynamic rather than a static binary definition.
Mike or Del, any thoughts about jury nullification as a?
He's nuts.
Well, I'm just wondering, it's obviously in the academic vernacular, but how often is it used? And
I don't know. That's a Del
I'm just
question.
wondering about it. Yeah.
For me, I find myself more in agreement with Tim than not, for sure.
Oh, dang it.
And let's start off this way. All juries have the power of jury nullification. They don't necessarily have the right of nullification, and the system almost never tells them that they have the power. But when they go into that jury deliberation room, their decision is their decision, and how they interpret the judge's instructions. If they ignore the judge's instructions, it's up to them. And to that extent, that's the way the jury system is supposed to work. The jury is supposed to do justice in individual cases. And how they understand the law and how they understand justice is our jury system. There's a check and a balance that I think works well in the criminal side. If the jury nullifies the law because it's unjust, as they did, for example, in the fugitive slave laws, that person's acquitted, and that is that. If it goes the other way and they convict somebody, maybe without evidence, they want this drunk driver, this person accused of drunk driving, they just want to send a signal that we don't tolerate drunk driving here. The judge has options. The judge can fix that by ordering a new trial. So the damage that nullification does can be fixed, at least to some degree, by a judge. But having a jury come in and saying, we think that a conviction in this case is unfair and we're not going to do it, for me, that's part of the reason why the jury's there.
Chris, Mike, Tim, any final thoughts? Chris?
Well, I think of what's the line about jury? It's the last outpost of a skeptical citizenry, right? And too much power in the hands of a prosecutor or a judge.
Mike, final thoughts, insights?
I'm the way Del framed it, that's making me think about it. It depends on which community we're in and what their vision of justice is. So obviously, I can think of like the fugitive slave law examples are one where I would be, yes, that's the justice-oriented decision. But acquitting someone in the South in the 40s accused of lynching because they don't see the justice-oriented approach of protecting the rights of Black people, I think we'd all agree that's not. And I don't know how to square that in my own head. I'm definitely. I don't like it that I'm evaluating this based on whether I like the ends or not. That's usually a way for me to be checking how I'm thinking about things, but I'm not sure what I think about it right now. I'm going to keep.
Well, how small D Democrat are you, Mike? I mean, this is the dilemma, isn't it?
Yeah. Yeah.
Well, that is the place to wrap it up. Professor Dickson, we really, really appreciate having you join us. You fit in really well. And I see so much of you in Mike in tonight's discussion here. And so you obviously had a major influence on him. And I watched a few videos about your status at USD and how popular and beloved you were. And so we're hoping we can get you back sometime in the future. If you're willing, you may not be willing after tonight to join us. So Del, thank you so very much for joining us.
Yeah, thanks.
Gentlemen, we're, I think, still planned to meet next week. We're going to be delving into Unit 6 question, and we're going to be looking at, gosh, I don't even know what the topic is. COVID. We're going to be looking at federalism and COVID and public schools, our favorite F word, federalism, which definitely applies to jury trials as well, given how different they are. Because I'm like Tim, I'm going, how in the heck, Del, did you get on 3 juries? You know, as an expert in the field, it says something about San Diego County or city, wherever you live there, because in my 40 years of living in my community, I've been rejected so many times just because I taught American government. Federalism is a main thing. So we'll be talking about some really interesting issues next week with federalism, COVID, and other issues. Until then, peace, love, yogurt tacos. Bye-bye. Bye-bye.